Missouri's lease termination laws mirror the same location-dependent framework we discussed in our habitability video. Because Missouri doesn't have a comprehensive statewide residential landlord-tenant act, the rules you follow depend heavily on where your property is located. The governing provisions are scattered across Missouri Revised Statutes, Chapters 441 and 535, which cover landlord-tenant relations and the eviction process respectively. Let's start with no-cause termination. For month-to-month tenancies, Missouri requires either party to provide at least 1 month's written notice before the end of the rental period. The notice must be given at least 1 full calendar month before the termination date, and it must expire at the end of a rental period. So if rent is due on the 1st and you want the tenancy to end on March 31st, you need to deliver notice before March 1st. For fixed-term leases, the lease expires at the end of the agreed term. Missouri does not require additional notice to terminate at the natural expiration of a fixed-term lease unless the lease itself requires it. If the tenant remains after the lease expires and the landlord accepts rent, the tenancy generally converts to a month-to-month arrangement under the same terms. For week-to-week tenancies, 1 week's notice is required from either party. Now let's cover termination for cause. And this is where Missouri's lack of a comprehensive statute creates both flexibility and ambiguity. For non-payment of rent, Missouri does not have a statewide statutory notice period requiring landlords to give tenants a specific number of days to pay before filing for eviction. In theory, a landlord can file a rent and possession action as soon as rent is overdue. However, the lease itself may require a notice period, and best practice is to provide written demand for rent before filing, both for documentation purposes and because courts generally expect landlords to have made a reasonable demand before seeking judicial relief. In practice, most Missouri landlords provide at least a few days' written notice demanding payment before filing. While this isn't strictly required by state law, it demonstrates good faith and strengthens the landlord's position in court. Some local courts have their own procedural expectations about demand notices, so it's worth knowing the customs of the specific court where you'd file. Here's where Kansas City and St. Louis come in. Both cities have their own local ordinances that add requirements to the termination process. Kansas City enacted a tenant protection ordinance that includes specific notice requirements before eviction filings. Landlords in Kansas City must provide tenants with a written notice, typically 10 days for non-payment, before filing an eviction action. The notice must include information about the tenant's rights and available resources. St. Louis has similarly expanded tenant protections through local ordinances. The city requires landlords to follow specific notice procedures and has implemented programs designed to connect tenants with assistance before eviction proceedings move forward. Landlords in St. Louis should be familiar with the city's current ordinance requirements, which have been evolving in recent years. For lease violations other than non-payment, Missouri's framework depends largely on the terms of the lease and any applicable local ordinances. Because there's no comprehensive state statute prescribing cure periods for specific violations, the lease governs. If the lease includes provisions for termination based on specific violations, including notice requirements and cure opportunities, the landlord can enforce those terms. In the absence of specific lease provisions, the general approach is to provide the tenant with reasonable written notice of the violation and an opportunity to correct it before pursuing eviction. What constitutes reasonable depends on the nature of the violation and the circumstances. Courts evaluate these situations on a case-by-case basis, and landlords who can demonstrate that they gave the tenant a fair chance to address the problem are in a stronger position. For serious violations, including criminal activity, drug-related offenses, and conduct that threatens health or safety, Missouri allows landlords to pursue eviction more aggressively. Missouri has specific statutory provisions addressing drug activity on rental property. Under the state's criminal nuisance laws, a property where drug activity occurs can be declared a nuisance, and the landlord can be held liable if they don't take action to address the problem. This creates a dual incentive. Landlords need to act quickly both to protect other tenants and to protect themselves from nuisance liability. Missouri also has a specific provision for situations involving methamphetamine contamination. Properties where meth has been manufactured are subject to mandatory cleanup requirements under the Missouri Department of Natural Resources regulations. The landlord must remediate the property to state standards before it can be reoccupied, and the contamination creates grounds for immediate lease termination. The eviction process in Missouri goes through the Associate Circuit Court in the county where the property is located. The landlord files a petition for rent and possession, and the court issues a summons to the tenant. The hearing is typically scheduled within a relatively short time frame, often within 1 to 3 weeks of filing depending on the court's calendar. Missouri's eviction process has some unique procedural elements. The case is tried before a judge. There's no jury trial right in Associate Circuit Court for these matters, unless the case is transferred to Circuit Court. The hearing is relatively informal compared to full civil trials, but the landlord must still present evidence supporting the grounds for eviction. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a specific period to vacate, and this is where Missouri has an important provision. Under Section 535.030, if the eviction is for non-payment, the court gives the tenant a period to pay the judgment and avoid eviction. If the tenant pays the full amount, including rent, court costs, and any damages, within the time allowed by the court, the eviction is stayed. This is Missouri's version of a right of redemption, and it applies specifically to non-payment cases. If the tenant doesn't pay or vacate within the required period, the landlord can request a writ of execution, and the sheriff carries out the physical eviction. The overall timeline from filing to removal is typically 3 to 6 weeks for uncontested cases in most Missouri jurisdictions. Kansas City and St. Louis may have longer timelines due to higher case volumes and additional procedural requirements under local ordinances. On the tenant side, Missouri provides limited but important grounds for early termination. If the landlord fails to maintain the property, and in Missouri this is evaluated under the common law implied warranty of habitability, the tenant can argue constructive eviction if conditions are severe enough. However, as we discussed in our Missouri habitability video, tenant remedies at the state level are more limited than in states with comprehensive landlord-tenant statutes. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Missouri has a significant military presence, including Fort Leonard Wood and Whiteman Air Force Base, making this provision relevant to tenants in those areas. Missouri enacted the Missouri Crime Victims' Rights Act, which provides certain protections for victims of domestic violence. While the state doesn't have a comprehensive early lease termination statute specifically for domestic violence, victims comparable to what you'd see in states like Oregon or New York, victims who hold valid orders of protection have some protections. Kansas City and St. Louis have additional local protections for domestic violence victims, including provisions that may allow early lease termination without penalty. Tenants in these situations should consult with a local attorney or domestic violence advocacy organization about available options. Missouri strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove the tenant's belongings, or take any action to force a tenant out without going through the court process. While Missouri doesn't have a specific statutory penalty provision for self-help evictions, as detailed as some states, courts will hold landlords liable for damages caused by illegal lockouts or utility shutoffs. And engaging in self-help will severely damage a landlord's credibility in any subsequent court proceedings. One practical consideration for Missouri landlords, because the state relies on a patchwork of statutes, local ordinances, and common law rather than a single comprehensive act, having a well-drafted lease is arguably more important in Missouri than in any other state. Your lease needs to fill the gaps that the statute doesn't cover, including notice periods for violations, cure rights, grounds for termination, and the consequences of specific breaches. A lease drafted by an experienced Missouri landlord tenant attorney is an investment that pays for itself many times over. Missouri requires landlords to return the security deposit within 30 days of the tenant vacating the property. The landlord must provide an itemized list of any deductions. If the landlord fails to return the deposit or provide the itemization within 30 days, they may be liable for up to twice the amount wrongfully withheld. Missouri also limits the security deposit to a maximum of 2 months' rent, which is more generous to landlords than states that cap it at 1 month. For the complete guide to Missouri lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.